Stevens.
Good morning. May it please the Court. My name is Bethany Stevens, and I'm an Assistant District Attorney from Middlesex. This is the Commonwealth's appeal of the motion judge's dismissal of the complaint in this case based on his finding that the open and gross statute is unconstitutionally overbroad.
Ms. Stevens, I know it's not your burden, but was the Attorney General informed that there was a constitutional challenge to the statute?
I did inform the Attorney General, and they indicated that as the Commonwealth was arguing for the upholding of the statute, that they did not need to intervene.
Thank you.
Thank you. I would just like to, the Commonwealth is here asking this Court to reverse the motion judge's decision. The open and gross statute is not unconstitutionally overbroad.
Just slow down just a little bit.
I'm sorry.
Thank you.
This statute does not sweep unnecessarily broadly into areas of protected expressive conduct judged in relation to the statute's plainly legitimate sweep. This Court has addressed the open and gross statute as recently as 2003 and 2004 in both Commonwealth v. Kessler and Commonwealth v. Quinn, and has recognized that judicial interpretation of this statute over the past 200-plus years has sufficiently limited the statute such that its reach to expressive protected conduct is minimal, if any.
Is there anything that we need to do to further limit the reach of this statute?
In the Commonwealth's view, no. Based on the Wardell language back in 1880, where the statute was, the elements of the statute included intentional exposure without necessity or reasonable excuse, done with the in a way to shock and alarm, actually does in fact shock and alarm, and then this Court's further limiting in Osceola, finding that in situations where there are willing and suspecting persons, specifically in theaters, in adult entertainment establishments, in those contexts, the statute cannot be applied to those instances.
Ms. Stevens, let me ask you this. In Osceola, as you know, the Court didn't pass on the question of the applicability of the statute on an unsuspecting or unwilling person. And I just wonder what your position would be with a Lady Godiva situation, which is a political protest, which I think this is claimed to be.
Right. I would suggest that under the elements and as the statute is currently interpreted, that factual situation would not be prosecutable under the open and gross statute. I think the Commonwealth would have difficulty in showing that the conduct was done in such a way as to shock and alarm, that it did in fact shock and alarm, and as well that it was done without necessity or reasonable excuse.
How are you going to show that in this case? How are you going to show that in this case? All I could see from the record was the police report said there were 150 people, including some children, but did you know who they were? I mean, how are you going to prove that there was in fact shock and alarm?
Well, currently, I would suggest that the police report or the statement of facts in support of the application for complaint establishes on a probable cause level. We had employees of the kiosk area actually calling the police, indicating that they were shocked and alarmed, that the police that were there actually did witness them themselves. They had the names of the witnesses. Obviously, the Commonwealth would have to produce these witnesses at trial to show elements of shock and alarm, not just nervousness or offensiveness, as was in the Kessler case. And then in addition to that, the statement of facts also shows that the police officer, when confronting the defendant, asked whether there was any psychological or mental issues, again, supporting the inference that there was a shocking and an alarming aspect to this conduct, such that it would make someone believe that there is something wrong with this person.
And you don't think that would be true if Lady Godiva rode her horse through town?
Depending. I mean, I think in that circumstance, everybody knew that she was going to be doing that, and that everybody turned their head except for the one peeping Tom that apparently wanted to be a suspecting and willing viewer. So I think under those facts, just the interpretation of the statute itself would kick out that conduct.
Ms. Stevens, what this suggests to me is that essentially what you've argued is that it's a case-by-case factual determination, and what that suggests to me is that dealing with this is not appropriate on a motion to dismiss, but you know, after the evidence has been introduced, as you know, the defendant has claimed that we really have no evidence here, and then a motion for a directed verdict at that time.
As applied challenge, as applied.
Correct. I mean, the Commonwealth would have to agree. It may be premature to answer that question at this point. As the defendant has pointed out, there was strictly an overbreadth, a facial attack on the statute. And as Osceola makes clear, the only protected expressive conduct that still might be within the purview of this statute would be an as-applied challenge when there is willing and or unwilling or unsuspecting persons.
Well, not entirely, because if as you know, he has standing. She has. Is it a he or she?
Or she.
She has standing to challenge, even if her conduct would be
absolutely under the overbreadth doctrine.
And so if you have the sort of Lady Godiva type situation, what must the Commonwealth bring forward to defeat an overbreadth challenge facially at this time?
Well, I would suggest that even with accepting those facts as a possible hypothetical, that would still not require, even if the court found that the statute could not be constitutionally applied to that conduct, it wouldn't require the strict medicine of striking the statute down. At most, it would only require a limiting construction. So if the court felt that...
Did he strike the statute down totally, or did he just say it can't apply to this case because her purpose was this political statement, this whatever kind of statement it was about Christmas?
He struck the statute down. It was solely a facial challenge to the statute, and the judge, when asked to clarify whether it was a facial challenge or an as-applied, stated it was a facial challenge.
No. What he did was he finds the statute under which the defendant is charged is overbroad. He allowed the motion to dismiss.
Correct, and by its very nature, an overbreadth challenge, the remedy of a successful overbreadth challenge is to strike the statute down. The only way that you would stop before that remedy is to limit it as applied. So the overbreadth doctrine in itself, it contemplates the remedy of striking, of a facial invalidation. And so if you don't meet the standard of the overbreadth...
Would you agree with me that if she and maybe a few others put on a theatrical performance on the day in question that was directed at anti-Christmas and they were nude, that'd be okay?
It's the Commonwealth's position that no, that would not be permissible.
Why?
Because well...
Not if there were signs saying that there was nudity, there was nude content in the outdoor stage, so that certain people who might otherwise be offended wouldn't have to view it?
It would be possible that under those facts that the Commonwealth wouldn't be able to show that there was no reasonable excuse or necessity for, and I would guess it would be the reasonable excuse part of the interpretation of the statute that would justify that conduct and making it not punishable under the open and gross statute. So it is possible that those scenarios...
If the Commonwealth didn't have the names and addresses of witnesses but could show that there were young children that were present, would that be enough to survive the challenge?
Well...
In other words, does the Commonwealth have the sufficient interest in children not seeing this to satisfy the shock and alarm aspect of the case?
I guess I see that a bit as two different questions. I mean, the Kessler was very clear that the tender years instruction would only go to whether it was done in such a way as to shock and alarm, but the Commonwealth would still be required to have witnesses that did in fact suffer shock and alarm. So just by putting a 6-year-old on the stand saying, I see this, without showing more, that would satisfy shock and alarm.
The private theatrical performance cases are different, aren't they? Because those are willing people that buy tickets, they want to see it. You know, like Hair. I was actually the trial judge that had to allow Hair in Springfield over the objection of the mayor.
Did you view the performance?
I did. I saw it on videotape up at Springfield Technical Community College because the mayor said there'll be no nudes on Symphony Hall stage. And I said there would be. But theatrical performances are different, aren't they?
Exactly.
Than public displays.
And that's why the Commonwealth would probably have to agree that an as-applied challenge at this time may be premature, because in understanding what exactly expressive conduct is protected, the circumstance really does make a difference. So in Osceola...
Same thing holds true for nude dancing in private clubs.
Correct.
People are there that want to be there, so they can't be shocked and alarmed. They're going there to see it.
And not only that, I mean, there's just some character to what makes nude dancing expressive conduct. It was important in Osceola when it looked at the statement of agreed facts that there was music playing. I think Cabaret made a point of that in their facts, that the patrons weren't mingling with the dancers weren't mingling with the patrons. There was no touching of themselves. So there was a certain context.
Excuse me, isn't there difficulty here that when a judge concludes that a statute is overbroad, the judge then has an obligation to go to the second step to see whether or not there can be some way that the statute as a whole can survive if there's a reasonable way for the court to limit it, which is in fact what this court has done in response to each of the challenges. As a practical matter, what we've done is cabin and cabin and cabin. So isn't the difficulty here that the judge could have reached this conclusion and could have added a construct that might have that wouldn't have struck down the statute as a whole, but might have been the basis for allowing the motion to dismiss.
Absolutely. I mean, that's what the overbreadth doctrine teaches, is that you're supposed to first look for a limiting construction available before you would invoke the strict medicine of the overbreadth doctrine and strike the statute down. The overbreadth doctrine is a chance for the judiciary to actually negate what the legislature has done, and that's a very limited time that the judiciary is going to do that, and is going to instead look for an interpretation that's going to be as narrow as possible, so to avoid those constitutional problems.
Let me ask you this question. Very often, particularly in the area of political speech, the intent is to shock. That is its intent, to shock. It's a wake-up call. How do we square that? And that is very protected. How do we square that with our jurisprudence that says, it's not okay if you shock an alarm?
I think the difference there that you look at is that there is a difference between pure speech and expressive conduct. The jurisprudence has recognized that the courts or the legislature does have a freer hand when restricting conduct as opposed to pure speech. And here, the open and gross statute, I think it's undisputed. There is no scenario you could come up with where it's going to run into actual pure speech. And even just in the expressive conduct forms, over the past 200-plus years, this statute has only been challenged on free speech grounds twice. And that just indicates the very small amount of times that this open and gross statute is going to butt into expressive conduct.
Well, it might be because in other occasions the Commonwealth hasn't chosen to prosecute.
Certainly not, because the
I
Commonwealth
mean, has the Commonwealth prosecuted, for example, every, naked runner across a football field?
And the Commonwealth doesn't have any interest in prosecuting people who are engaging in legitimate lawful exercises of their First Amendment and Article 16
Running naked
rights.
across a football field in front of thousands of people is...
I would suggest there's no expressive conduct associated with that scenario, so that we wouldn't be running into that same problem on the overbreadth, at least on the overbreadth doctrine.
What do we
would
do
not
with all
apply.
these cases that the judge cites in his memo, RAV versus Minnesota, Forsyth County, Gettysburg College, so forth? You're aware of all those.
Correct.
They seem all to be acts, that are shocking to people, Nazi slogans, signs, all that kind of stuff. And in every single case, the court struck it down.
And in those cases, they were dealing with ordinances that on their face dealt with expressive conduct or speech in themselves. In the RAV case, it was an ordinance that actually specifically said you're not allowed to put a symbol or
a burning cross. Wasn't that the burning cross case?
that was the conduct that was at issue in that case, and that the and I believe too that it wasn't even an intentional part. It just had to produce the shock and alarm, so it didn't necessarily have to be done with any particular, or at least the intent was on a protected level, so that the court, when looking at it, was seeing it as a regulation of speech as opposed to conduct. If it was just, and I think they said in that case that if it was an ordinance that just prohibited the burning in people's yards, as opposed to limiting it to cases where there was an expressive element to the burning, then there might have been in a better place, as limiting the statute as opposed to striking it down.
Could I ask, I haven't read, I confess, the Weiner against Sludds, the 2003, I can't tell from which district court it is, but there the plaintiffs, the court held that the plaintiff's intention to use a public park to create a living nude peace symbol was expressive conduct. Do you know that case?
I do. I just know that in the circumstances of that case, it was an issue of where the park was not granting a permit for this kind of theatrical or this kind of production, and it was more of an issue of whether there was too much discretion in the permitting granting authority to be able to make this case-by-case determination on whether there is going to be First Amendment protected
Let me ask the
conduct
question.
there.
Do you take issue with Judge Singleton's statement, never mind here, but just with his statement that a blanket prohibition against public nudity without making an exception for expressive conduct, i.e. that which is protected by the First Amendment, is unconstitutional?
I agree with that statement, and this court agreed with that statement as well in Mendoza when it struck down
Right.
that ordinance, absolutely. But here, the judicial interpretation of the open and gross statute makes it absolutely clear that it's not a blanket prohibition on public nudity with no exception for expressive conduct.
So there may be judicial glosses on it, but they're not judicial glosses that have addressed this particular kind of activity.
It's the Commonwealth suggestion that it has addressed, that just by the Wardell language in 1880 that says that it's done without necessity or without reasonable excuse, that would cover those situations. There hasn't been a lot of interpretation of that because it's a very rare when the disputed issue at trial in these cases is that there was some reasonable excuse or necessity. So it hasn't really been fleshed out at this point. This seems to be the first case that's really raising that possible question that was left open in Osceola. But it's the Commonwealth's position that that language from Wardell, the no reasonable excuse or no necessity, that would cover that concern.
But surely political expression, you don't have to give a reasonable excuse. I mean, political expression goes to the heart of the First Amendment.
Correct, but if you're engaging in political expression, then you have a reasonable excuse for why you're engaging in your public nudity that falls under the statute, similar to the disorderly conduct statute that says for no legitimate purpose. It covers those areas and takes away those First Amendment concerns.
Thank you, Ms. Stevens.
Thank you.
Mr. Beck?
Commonwealth, we just asked you to reverse the motion judge's decision. Thank you.
May it please the court. I guess one of the problems about going second here is that the court seems to have anticipated some of my arguments, and that I have Hare and Lady Godiva both in my notes here as something I wanted to bring to the court's attention.
Explain to me why the municipality or the state couldn't prohibit people from being nude on public streets.
Because sometimes that is a First Amendment right. I suggest the one other example I would use is the case of Spencer Tunick, who is the plaintiff in Tunick v. Safer, which is mentioned, which is referenced in my brief.
Well, nudity isn't nudity is a First Amendment right, or expressive
conduct that may include nudity is a First Amendment right. Mr. Tunick,
in certain circumstances.
absolutely.
But
I'm
not
not
in
suggesting
but not in all circumstances. So how can you have a facial challenge?
because it is overbroad. That's the problem.
Why is it overbroad as applied to your? Why is it overbroad, Mr. Beck, as applied to the conduct here?
As interpreted by this court with the limitations on it.
Well, first of all, I suggest that whether it's overbroad as applied to my client is not before this court. That is, the facts of this case are, at this point anyway, irrelevant to the analysis, in that it was found to be overbroad, in that she has, as the court pointed out, she has the right to bring it even if her conduct is not part of the overbreadth under the overbreadth statute. If it
Yes, but the Commonwealth argues with some basis that in fact the statute is not a blanket prohibition. It's a prohibition that has been narrowed by judicial gloss. So let me ask the question differently. On what basis do you argue that your client's behavior falls outside the judicial gloss that the courts...
Again, Judge, I will answer that, but I just want to point out that I do not have to show that in order to show that the statute is overbroad. That is, if there are other people other than my client whose First Amendment rights are abridged, she has standing to claim that the statute is overbroad, irrespective of whether the statute is overbroad as applied to her.
Yes,
So-
unless one can conclude that the judicial glosses, multiple glosses that have been imposed by courts sequentially over the decades, have in fact made this not a blanket prohibition, but a quite narrowly tailored prohibition.
That's correct, and that is the issue, not my client's behavior, but whether it's narrowly tailored. And I would suggest, as the court pointed out, Lady Godiva, but in more practical, Spencer Tunick, who takes photographs of large groups of naked people, who has done this over the world, literally across the world in many, many countries, many, many cities, may well have failed to do this in Massachusetts because of this statute. That is, it is clearly, he's a recognized artist. The court in Tunick recognized that as such.
But I mean, we're not talking about getting a permit here and whether or not he would be denied a permit to do such a photograph or such an artistic presentation in Cambridge Park somewhere. What if he says, well, I think I'd like to photograph people having sex on a sidewalk in Cambridge, so this is expression, it's my view of art, I'm just going to go out and ask a couple people to have sex and I'll just take photographs. Why?
I guess the question would be for the court whether that would be considered artistic, and I think there's a very there's a good argument that that would not be recognized as artistic by most people.
Well, I guess it would be if you say this fellow's as eminent as he is in this kind of photography. Does it make any difference where this occurs? This occurred in a public square. Suppose she had done this, or her group had done this, out in front on a street in an elementary school at 3 o'clock when all the kids come out to get on the bus. Different? Not different?
Not different, I would suggest.
Because it's expressive conduct.
I suggest it is expressive conduct, just like
Just because she says it's linked to a political campaign?
Again, that's something for the jury to decide if this case were to go to trial, whether that is, in fact, expressive conduct. But I'd suggest that many of
Don't
these...
get within the First Amendment unless... In other words, if somebody just decides that it's too hot in summer, just too hot, or they want to be on a beach because they want to be on a beach with no clothes on, you're saying that no town can regulate that?
Oh, no, that would not be expressive.
What would be, I guess if you say that applying the statute as it has been narrowed over the decades or centuries, at least in the first instance, to what happened here is unconstitutional.
Yeah, I don't know that I agree it's been narrowed other than for private clubs. That is...
But what about all those elements that have to be shown about shock and alarm and that somebody was in fact shocked and alarmed?
I suggest in the context of First Amendment, shock and alarm, at least the fact that somebody is shocked and alarmed is essentially a heckler's veto, which the courts have universally decided is not appropriate. As the court pointed out, political activity is often intended to shock, and so is art. I suggest good art is often shocking, and deliberately so. And the fact that it's shocking and that somebody is therefore shocked does not take, I mean, much that is protected by the First Amendment is shocking, and people are shocked by it. And I suggest that does not really...
What would you say would be, how would you define a permissible regulation?
Well, I think the New York statute, which is in my brief, which says that this shall not apply to any legitimate, essentially, it doesn't use the word, but any First Amendment activity, any serious artistic, literary, or political activity.
And so then one has a trial on whether or not the activity meets the New York statute.
Correct. And that could happen, but I suggest here...
Can't we do that here? Can't we say, here's the statute, but you can only apply it to non-artistic political activity?
You could.
Therefore, wrong to dismiss, on to trial.
Isn't that what the judge should have done in this case? In other words, once a judge in an overbreadth context recognizes that there's a potential problem, doesn't the judge then have an obligation to go to the next stage to see whether or not a gloss can be applied?
Perhaps in theory, although I will say that in the trial court, it is much less likely to happen than it is in the appellate courts as a practical matter.
In effect, the cases you're citing, the judge cited, have amended the statute, assuming the validity, assuming they apply here, to put in that exception that New York has literally put in, right?
Many of them did, yes.
Yeah, so we've got a statute now that's been, in effect, judicially amended by Supreme Court of the United States, other places, and
But this
on
court
to
has
trial, but not dismissed out of hand.
But this court has never so limited it.
I see.
I'd also point out that the case-by-case...
So there's a shred of expressive activity. Going back to the hot day in July or August, if somebody wants to walk around naked and says, well, you know, it's too hot, I'm going to be naked, but I'll protest the Iraq War while I'm doing it, and puts a hat on and says, I'm against the Iraq War. And he is against the Iraq War. Okay?
I suppose it would depend on if a jury were to find that his...
Oh, it is. He's got a double purpose. You know, in the meantime, everybody's calling up the police saying you got somebody walking around here completely naked with a hat on. It's okay?
I suppose so, Judge.
What about
I mean,
what about
obviously, I
without-
don't think it's likely to happen.
What about without
You don't
that?
think it's likely to happen?
Well, how does that differ from what the person did here? That it was cold.
What
was
happened here was,
June.
first of all, the protest was actually initiated by a different person, not by my client. My client was not the person who organized the protest. The protest has been going on for several years prior to this, so I suggest that,
Were there other people that were nude in Harvard, in the kiosk area of
not
Harvard
to
Square?
my knowledge, I wasn't there, but as far as I know, no,
Just she.
just she.
Explain to me, how does this differ from an ordinance against burning things on public streets? You know, burning things is occasionally expression, it's not a conduct used to express
Flags.
political views.
Well, I suggest that the danger involved, even these days, the EPA regulations are certainly something to be taken into consideration. I suggest that expressive conduct that forms an actual physical danger to somebody else has to be treated differently than one that does not. I mean, I suppose you could say that firing a gun somehow is a protest, but obviously that would be.
Mr.
But
Beck-
when you're talking about physical danger, I think it's in a different category.
But if it could be done without physical danger, it would clearly be protected, wouldn't it? Suppose I want to burn the U.S. Constitution in front of everybody,
I think if it's done without physical
3 or 4
danger,
pieces of paper.
I think Texas v. Johnson makes it clear that it would be protected.
Mr. Beck, back to our facts. In this case, this was an anti-Christmas demonstration that had been going on for a number of years.
Yes.
And
Did the people in the, this is 2005, as I recall,
Yes.
when did the events take place, 2005?
I believe so, yes.
All right. Well, let's assume that they do. Did the people who were mounting this anti-Christmas demonstration come from someplace into the Harvard Square area? Were there a number of people?
There was a few people. They came from somewhere in the
And
neighborhood.
they
I
had
mean.
placards or something?
Yes.
And was your client with them when they approached Harvard Square?
I'm not sure. She knew about it. She went to Harvard. I believe she went to Harvard. I'm not even sure, frankly, but I believe she went to Harvard Square with the express intention of meeting them. It wasn't that she just happened to be there.
Okay.
So
Well, go ahead.
I just want to make sure I understand what you're saying. If somebody wanted to do a documentary on the First Amendment and decided one of the themes was to show somebody in a state of shock and alarm, an unwilling and unsuspecting person in a state of shock and alarm. And that's the theme of this documentary. So two people go on a public sidewalk in front of somebody's house and engage in intercourse. And the owners of the house come out in the state of complete shock and alarm, unwilling and unsuspecting. Is that protected?
I don't think so, but I don't think that. I think it's kind of interesting that you're only protected from shock and alarm if there's nudity involved, and if somebody does anything else to shock and alarm you.
Well, if you're unwilling and you're unsuspected.
But if somebody were to do something, stage any kind of event that did not involve nudity outside the same house, we seem to have a very strange double
So
standard.
we appear to be in agreement here. You appear to agree that this dismissal of this was wrong. That the statute, so long as it's not applied to First Amendment activity, can't be done. And this case has got to stand trial to see what this woman's motivation activity was.
I would certainly take that as a fallback position. I don't know that I would go so far as to say I agree with it, but I certainly think if the court finds that dismissal was to harsher remedy, that would be the result.
Is anti-Christmas political protest?
I think so, yes.
Why? I mean, it's just a religious day. It's not in the same league as burning the class or the flag or the Constitution or Nazi symbols.
First of all, the protest is not against the religious aspect, but the commercial aspect. Also, but even an anti-religious...
Political?
I'd say yes. I'd say even if it was anti-religious, Just like
Hey,
we're
suppose on April 20th, if some people want to walk around Harvard Square naked to protest Hitler's birthday, is that political?
again, I'm not sure. I didn't know that was Hitler's birthday, frankly. It could be, depending on if they're sincere. If
Mr. Beck, one of your answers to Justice Glaney perplexed me. I thought the whole basis of your argument here was, I understand a sort of fallback position, but that in fact the motion to dismiss was properly allowed because somewhere out there is some expressive conduct which this statute criminalizes.
Correct.
And it should not be criminalized. And regardless of the facts here, your
Yes.
client is entitled to raise that issue.
Correct.
So how can you agree with Justice Glaney that the motion to dismiss was improperly granted?
I didn't say it was. I said if the court finds that it was improperly granted, my fallback position would be that we would have a trial on it. I would just like to point out briefly that Commonwealth versus Kenny, which was later cited in Rule 16 by the Commonwealth, is inapposite here in that it applies New York v. Ferber, the Supreme Court case, and the Supreme Court has held in Ashcroft v. Free Speech Coalition that Ferber applies only to child pornography. It is not a general First Amendment standard.
Thank you, Mr. Beck.
You.